all of you who are coming from different parts of the world. Yeah. This is Teresa Tian from Hong Kong. I'll be your moderator for this session. Well, I recognize a lot of familiar faces, members of our ACAP, and there are also new faces. So warm welcome to all of you who are joining us the first time. On behalf of Professor Catherine Brown, the president of ACAP, ACAP stands for Active Aging Consortium in Asia Pacific. I would like to briefly introduce ACAP to you. Let me share the slides. Okay. Okay. Can you see the slides? I cannot move the slides.
Show again.
Maybe Anne, can you share the slide for me? Thanks. Well, ACAP is a voluntary information sharing body open to people of all ages, disciplines. So our aim is to share friendship and best research findings and best practices to promote active aging. Members will receive our free quarterly bulletin, and you will be invited to our monthly webinar and our annual conference. So you can see that this is our conference hosted by Hong Kong in 2018. And so if you want to be our member, please go to our website, which is listed here.
Make sure that you
and
are
yeah.
Make
so
sure
as of today, we have more than 1,400 members around the world, and most of them are gerontologists, geriatricians, educators, and practitioners from more than 40 countries. So primarily in the Asia Pacific region. And I want to remind you that membership is free, so please join us. So every month we have webinar topics. So these are the topics before today. Today we are having this central depository for 3 instruments of peace. And the next one I would like to invite you to will be another webinar in August addressing aging issues in Southern Africa. And also we have another one in September. It's on the population of Japan. So today we have more than 150 registrants from more than 20 countries. So you can see, where are all of you from? Okay. So today we are going to have a very important topic. We all know that the whole world is aging. So we are all living longer, but not necessarily be healthier. And Hong Kong is now a super aged society with 21% of our total population, that is about 1 in 5, who are aged 65 and above. And dementia correlates with age. That means the older we are, there is a bigger chance of having dementia. And worldwide, there are over 19 million new cases of dementia, implying about 1 new case in every 3 seconds. So when we lose our mental capacities due to dementia, stroke, or accidents, we are unable to make decisions for our health, financial, and legal affairs. Fortunately, there are the 3 instruments of peace, namely the will, enduring power of attorney, and advanced medical directive are the important legal tools that can help us to plan for our future financial and medical needs when we become incapacitated. So I'm sure you all know about will, which is a legal document containing instructions as to what should be done with one's money and property after one's death. And the second one is enduring, or called the lasting power of attorney. It's a legal document that allows a person who wishes to give his or her power of attorney to someone while he or she is still mentally capable, to appoint one or more attorneys to take care of his or her financial matters in the event that he or she subsequently becomes mentally incapacitated. So advanced medical directive, the third one, which is also called the living will in the US, is a legal document in which a person specifies what actions to be taken for their health if they're no longer able to make decisions for themselves because of illness or incapacity. So today's webinar will be to explore the implementation, the storage issues of these three important legal documents, and to discuss opportunities and challenges of establishing a central depository in three jurisdictions, namely Australia, Singapore, and Hong Kong. So we have the honor to invite three distinguished speakers to speak on behalf of the jurisdictions. So each speaker will have 50 minutes to share. If you have any questions or comments, please type and post them on the Zoom chat. And also please include your name and country. The speakers will answer your questions at the Q&A session at the end of all the presentations. Okay. So during the presentation, please mute your microphone. So without further ado, I would like to introduce the first speaker, Mr. Brian Mitchell. Mr. Brian Mitchell is the Managing Director of Mitchell Solicitors Australia. Brian assists clients in wills and estates, trust, and elder law. His expertise is recognized by the Queensland Law Society, being an accredited specialist in succession law. Brian and his firm Mitchells were recognized and ranked highly in the influential Doyle's Guide as leaders in wills and estates, both in Queensland and nationally. He has served as chair of the Queensland branch of the Society of Trust and Estate. He is presently immediate past chair of the Society of Trust and Estate Practitioners in Australia, a member of the advisory board for the University of Queensland Law School, a fellow of the Tax Institute, deputy chair of the Queensland Law Society Succession Law Committee, and deputy chair of the Succession Law Specialist Accreditation Advisory Committee. Brian has served on various boards of community organizations and was a sessional lecturer in business law at Christian Heritage College. A very impressive bio. So over to you, Brian.
Thank you, Teresa. That was very kind of you. So I'm just going to share a screen, everyone, and so that I can have my slides up. So hopefully everyone can see that. There you go. So that's a mugshot of me, and I'll just get past that, and I'll press my timer too, so I don't speak for too long. So, and that'll be up for a millisecond if you want to connect on LinkedIn, and your time is up. There you go. And so what are we going to talk about? We're going to talk about Australia because I'm an Australian lawyer, but it's really important to, when you think of an Australian lawyer, you think, well, you know, they just do the laws of Australia. Well, it's a bit tricky to be familiar with all the laws of Australia because we're a federation. And that just goes back to our history. We were a group, not actually, but a group of separate jurisdictions historically. And with the formation of a federal government, not very long ago, it was 1901 that we had the formation of a federal government. So, and that constitution that is more it's less about rights and freedoms and more about a power brokerage between the powers of the states and territories and that of the central body. And so what power remains in the states and territories? Well, that's the laws about succession, powers of attorney, and a whole stack of other things. So all the things we're talking about today is state and territory based in my country. So by way of example, you've got in New South Wales, you've got separate laws dealing with powers of attorney, et cetera, and wills. Similarly in Queensland. Don't get me wrong. We all, as a country, have a common historical background, common law background, and so there's been, a common foundation. And our High Court, which is our highest court in Australia, adjudicates not only federal law but also state law. So we get a harmonious development of precedent in our country. Thankfully, we don't get separate precedent development. Having said that, we have separate governments, state governments that deal with these things. And so we've got different acts of parliament. Good segue to Queensland. So Queensland's had the ability to have a type of enduring power of attorney, very narrow, since 1990. That document was only for, and I shouldn't say only because I know some jurisdictions on this call have that only as well, only the delegation of property and financial matters delegated from 1990 onwards. Then Queensland, leading the country, enacted legislation in 1998, the Powers of Attorney Act, which expanded the ability to not only delegate financial matters, which was defined more broadly and understandably, but also for personal matters, where you live, what doctor attends upon you, authorising medical procedures. So, and a whole stack of other things defined as personal and health. So that expansion in 1998 was then, in a sense, not cut and pasted by the other jurisdictions, but the ideas. No one wants to copy one another. The ideas were then replicated in other jurisdictions around the country to come up to fast forward 2024, and we have this common, I suppose, there in each jurisdiction in Australia, except there's some modification in South Australia, you can delegate financial matters, you can delegate personal matters. Regrettably, they're all defined differently. And not every jurisdiction recognises an enduring instrument in other jurisdictions, even in Oz. So it's a little bit of a challenge. It's a little bit of a challenge. So I'll just jump also on the idea of, we're looking at the three instruments of peace. So, enduring instruments, jolly wills and so forth, and advanced health care or advanced health directives. So not every jurisdiction has legislation that deals with advanced health directives. Queensland does, WA does. New South Wales for advanced health directives relies on the common law. And so the common law can only go so far without legislative involvement. Such directives are persuasive, but one would argue not binding. Well, at least I can only speak to Australian law in that regard. So in Queensland, as long as you're in an advanced health directive, you're giving a directive that is well understood and within the framework of the law, it is binding. Is there a national register? Well, I should stop talking now because the short answer is no. There is no national register in Australia for anything. But there are some registers, and I just want to talk about that. So we talked about, okay, so no state or territory has a register of wills or trusts, and there's no federal initiative in that regard. But it's really interesting. Tasmania. So those of you that are curious as to the shape and form of Australia, you might want to get up on Google Maps and just see all the different jurisdictions. You'll see right at the bottom of the country, and I'm sorry for the Australians joining this meeting, of course you know where Tasmania is. Right at the bottom of the country, there's the state of Tasmania, which is an island in itself. And so that state has legislation dealing with enduring instruments, powers of attorney, whether they're enduring or not. Not only you must register to operate. So there are two steps to operating as an attorney under a power of attorney in Tasmania. Clearly, you're appointed under a valid instrument. But secondly, before you can do anything, you must register the instrument. And so my 2 cents worth is if we were to move to a federal model in Oz, that would be the preferred model. Validity has 2 steps. Validity is execution of a valid instrument, whatever that means, and registration. So registration doesn't perfect that which could otherwise be invalid, but it must be registered. In other words, you could find out later in a court application that the instrument is invalidly executed or the adult lacked capacity. So registration doesn't, I suppose, represent to the community it's a valid instrument. It's just a requirement that it be registered. And for I know my fellow panelists may have different views on that. I'm keen for that as a model here in Oz, that registration does not indicate validity. It's just a requirement. And which is a really good segue. Why do I wish for enduring instruments to be registered? And I just want to park on this not too long, but I'm very keen in my country for there to be a national register of enduring instruments, at least, even not so much to perfect the document, but a requirement, so that there is a light on the instrument, that people are operating. I know there's a lack of privacy and so forth, and people have different views on this, but we have a report on elder abuse, a national response by the Australian Law Reform Commission. It goes for several hundred pages, and one of a gazillion recommendations on how to combat financial elder abuse is the further regulation of enduring instruments. So those of you that are in jurisdictions that are just haven't really got a proper enduring instrument yet, be warned. If you do this without oversight, without regulation, you'll have the same issues that we have in this country, and that is rampant elder abuse. And the instrument of abuse is the enduring instrument. So, and that's, in my 2 cents worth, that's because of a lack of oversight and a lack of supervision. We need a spotlight on these instruments. So there's a recommendation for a national register but that recommendation, federal recommendation, was coupled with there being a national enduring instrument. So we're same, but different in this country. We don't have a consistent and harmoniously identical enduring instrument. So that's a long way off. There's been extensive submissions nationally, but I don't even know if I want to put it in the category of work in progress. It's an activity that appears to have completely and utterly stalled. Those of you after this meeting, if you want further information about the initiative for the National Register or the report on elder abuse that was published and the recommendations, just let me know and I'll shoot you the link. It's for good reading. It's a bit sad though. So there's the recommendation. I just want to talk about WA once again. Western Australia. Once again, we live in a federation, and that makes my life very interesting. I enjoy living in a federation because it fascinates me how different state governments solve problems in a different way. One of the things that the Western Australian government does, which I think is a wonderful idea, is if in doing an enduring power of attorney, if you tick the box that says this thing doesn't start unless I lose capacity, then if you do that, under Western Australian law, the attorney cannot operate under that instrument unless you apply to the tribunal of Western Australia there, and there is a declaration of loss of capacity, yeah, and the instrument is registered there. So in a sense, in WA, you've got a de facto register of enduring instruments there, but only those instruments where the principal, the adult, has ticked the box. I want this to start when I lose capacity. Of course, you could tick the box. I want it to start now, and the statutory position is, well, the common law position is, for those of us in the meeting, we all know this, when you delegate to an agent, the delegation ceases where the giver of the power, the principal, loses capacity, but statute modifies that common law position that it endures beyond that. So you can appoint someone immediately. But WA's got that de facto register, as opposed to Tasmania, compulsory register for not only enduring instruments, but also any instruments that it's going to operate in the state. Oh, just quietly, Tasmania also recognises broadly foreign instruments, unlike any other jurisdiction in Oz, for delegated power. But before you operate in the state, you've got to register the jolly thing under their register, because you can't operate it unless it's registered. So I'll just go to my next slide. I just want to end on, in my couple of minutes remaining, the fact that there are no government initiatives for registers. I was personally involved in a think tank in Queensland, where heads of government, we all met for nearly a year to discuss whether or not it would be a good thing to have a register for wills. You might find that interesting, and we all thought, we all thought it would be a good thing to have a register of wills. We were deeply concerned, without talking out of school too much, that making it compulsory would be very difficult, because we live in a federation, and this is just one state, and someone might have an instrument in New South Wales, and B, we live in a global community. And so having a compulsory register, we found, would be very challenging to implement. So where we got up to in our recommendations to government was that it would be good to have a register, but it's not compulsory, but it gives advantages to people if they register there. And I won't breach confidentiality and just share what we thought those advantages could be. Needless to say, that was a long time ago, and government has no appetite in Queensland to consider that recommendation, so that went nowhere. There are private initiatives in Australia for will registers. One, curiously, that is gaining enormous momentum in the country is a lost will register, because people know there's a will, can't remember which law firm, and so they then advertise in their local periodicals, say in Queensland and New South Wales. So this lost will register pulls together all the adverts nationally of lost wills, and people can advertise there as well about a lost will. And it's becoming part of best practice in Australia to search the lost will register to make sure you really do have the last will and testament of your client. So that's actually, even though that's voluntary, that's something that's really working in this country. It's gaining momentum. And I think the founders, which is a not-for-profit, are strongly considering sharing their ideas and intellectual property internationally to try and do some good in the community there. There is a will register privately by the same organisation, and that's got limited interest and uptake. People kind of see the advantage for such a voluntary and private thing, but they haven't really taken up on that. And that, my friends, is my 15 minutes. Thank you.
Thank you so much, Brian. You're right on the dot. Okay. Well, Australia is such a big country. I learned that it's the world's 6th biggest country in the world. And there are states and territories. So now we learn from Brian that there is no national level central depository, but only Tasmania has one for power of attorney, enduring power of attorney. And I'm also very interested to learn about, that elder abuse and the relationship with enduring power of attorney. And also your last point on the lost will registry is also very interesting. So let's talk about this more at the Q&A. Okay, the second speaker, I have the honor to introduce Professor Jeffrey Chen Hua Dek. He is a senior counsel of the Supreme Court of Singapore and also an adjunct professor of the law faculty of the National University of Singapore. He is also a senior director of TSMP Law Corporation, Singapore. He has served for 45 years in the Attorney General's Chambers of Singapore, where he headed the Civil as well as the International Affairs Division before retiring as the Deputy Solicitor General. Jeffrey was chairman of the United Nations Commission on International Trade Law, chair of various UN working groups, vice chairman of Singapore Red Cross, and president of the Medical Legal Society of Singapore. Presently, he is the chairman of the Public and International Law Committee of the Law Society of Singapore, co-chair of the Forum on International Conciliation and Arbitration, and assistant governor of Rotary International District 3310. He is a fellow of the Chartered Institute of Arbitrators, the Singapore Institute of Arbitrators, as well as a senior mediator of the Singapore Mediation Center. Again, very, very experienced and impressive bio. So over to you, Jeffrey. Thank you. You have to mute yourself. Unmute yourself. Thank you.
My apologies. Okay, my apologies.
No problem.
Now, I'd like to looks like I've got to go back to my slides. I need to get back to my slides. I'm afraid I may have just. I seem to have lost my slide somewhere. Just a moment now. Okay, I think I've got it back.
Good. We got it.
Okay, right. Well, again, thank you very much, Teresa, and good morning, everybody. I'd like to thank ACAP for inviting me to share my views on this topic of the 3 instruments of peace. And in particular, I'd like to thank Thelma Kay, who's among us this morning, for giving me or informing me of this opportunity. Now, today, we're talking about 3 instruments of peace. Which are, as Teresa mentioned, wills, lasting power attorneys, also called LPAs, and the Advanced Medical Directive. But to me, these are not the only instruments of peace, because there are other instruments of peace which a person would find peace with as he moves into his or her senior years. And these are the power attorney, which serves a different purpose from the lasting power attorney, and the advanced care plan, which again supplements but does not substitute for the advanced medical directives. All of this we'll go through in a shortly. Now, all are legal instruments except for the advanced care plan. In other words, they govern instruments which are governed by law. And here, I think we need to emphasize that Singapore, like Hong Kong and Australia, is a common law country. Our legal principles are similar. So unsurprisingly, there's quite a bit of similarity between the way our countries deal with these 3 instruments of peace that we're talking about this morning. So what I propose to do this morning in the time that I have is to give a brief description of the position in Singapore with regard to wills, lasting power attorneys, and advanced medical directives. Now, firstly, wills, as mentioned, is actually a direction relating to the disposition of property after death. And a will is addressed to a named executor. There's a person named in the will to carry out the directions of the testator. The testator is a person who made the will. In Singapore, like I believe in all the other countries, our wills are governed by the Wills Act, and the Act is very old, it's 1838, as well as principles of common law. There's a huge amount of jurisprudence that has been developed over what wills are and how they are to be regarded and implemented. And we share this jurisprudence with Australia as well as with Hong Kong. Validity of a will depends on certain requirements being satisfied. And that's true of all legal instruments. Firstly, of course, capacity. In other words, whether the person is able to make the will. In other words, to put it simply, whether he's of the right age and he's got a mental capacity to decide what he wishes to do with his property after his death. Then it depends on formalities. There must be formalities before will to be valid. The usual requirement is that it must be signed by two witnesses who themselves must be capable of being witnesses. But the exception, for example, the wills of soldiers and the wills of mariners do not need to satisfy formalities in order to be valid. There are reasons for this, but we don't have time to go into that today. Interesting to note and important to note that a will can be revoked at any time. So anytime a person makes a will, if he revokes his will, then that will is invalid. Now, how are wills revoked? Of course, you can declare that you revoke your will, but a will can be revoked by, firstly, another will. A subsequent will revokes an earlier will automatically. And something that's not well known, wills are revoked by marriage. If you make a will and later you get married, that will is revoked. It's no longer valid. And there are many instances in our Singapore jurisprudence where courts have to decide in situations where a testator has actually revoked his will by getting married without knowing that he had revoked his will. So if there's no will, either because the will was never made or because it's been revoked, often by reason of marriage, then the estate of the testator will be distributed in accordance with the provisions of the Intestate Succession Act, where there's a schedule that describes who gets what, depending on how you're related to the deceased. An important point to note in Singapore, and I do not think it applies in Hong Kong and in Australia, is that estate of deceased Muslims are not governed by common law. They're governed by Islamic law, and Islamic law has specific provisions as to how the estate of a deceased is to be distributed. And there are various mandatory distributions which cannot be can be waived by the testator. And this is important to note. So what does it mean? All this means that it is very important that we find a will when the testator dies, because a will is legally effective and binding on others. In other words, others can rely on the will in the transactions with the estate of the testator only when the will is probated by a court. You need to produce it to a court and obtain what is called a grant of probate from a court before you can rely on the will in order to handle or deal with the estate of a testator. Problem is that because revocation can be made in any time, at any time, and can be revoked by marriage, it's very difficult to find whether or not a will has been revoked. Right? Because a subsequent will revokes a previous will, there will be many disputes over whether or not a previous will has actually been revoked. And this has actually reached to some severe degrees in Singapore, disputes over revocation of wills by subsequent wills. And interestingly also, and importantly, a will can be supplemented by codicil. You can make a will and then you can expand on it by making another instrument called a codicil. Again, there's no requirement for codicil like a will to be registered. So because of this, very often when a deceased dies, and because of the necessity to find a will in order to ensure that the deceased estate can be dealt with by those who are entitled to the estate, then there's often a search for wills when a deceased is the will of a deceased person. Now, because a will can be kept anywhere, often a will is kept with the solicitor that drafts the will. But that is not always the case. And in fact, it's often not the case. So there's an established practice in Singapore, and I hear the same in Australia, whereby searches for wills are made through the law firms. In Australia, now we hear there's actually a register kept by the Law Society. There's some kind of record of wills. In Singapore, it's very often for solicitors' firms acting for estate of deceased persons to announce in the Law Society publications that they are acting for the estate of a deceased. And if anyone knows where the will of the deceased is, please let them know. So that's a position in Singapore. So with regard to Singapore, the position with regard to the registry of wills is very simple. There is no registry of wills. Now, lasting power of attorneys. This is something which is fairly new, and we are still learning more about it in our jurisdiction. A lasting of power attorney, to use the terminology of the Act, enables a donor to appoint a donee to make decisions on his or her behalf if he or she loses mental capacity. This is, in a way, a power attorney given in advance of when you'll not be able to act for yourself. It is statutory and is established by the Mental Capacity Act of 2008. Now, the Mental Capacity Act of 2008 revokes the earlier Mental Disorders and Treatment Act, which is actually based on somewhat Victorian understandings of what constitutes lack of mental incapacity. So the donee of a power of attorney, of a lasting power of attorney or LPA, can act for the donor in respect of two areas, either personal welfare or property matters. And these are regarded as distinct areas. In order to confer on a donee a power, an LPA, the donor must use a prescribed statutory form. And there are two forms prescribed by law. There's Form 1 under the Act, which enables a donee to be conferred general powers, and Form 2, where the donor can customize the powers that he would like the donee to be able to exercise on his behalf when he lacks mental capacity. Now, Form 2 is required by law to be drafted by a lawyer, by a solicitor. The reason is because he wanted to ensure, or rather the framers of the Act wanted to ensure that the donor knows exactly what he is doing when he confers all these specific powers, in addition to the general powers, to a donee to act for him later on when he cannot act for himself. Now, the Act has numerous restrictions on donors and donees. I should add that the Act was enacted after a very long period of consultation by the government. I think it was more than 10 years of consultations, focus groups, research, and search for precedents and models before we finally decided on the form of lasting power of attorney in our law. Basically, the provisions are complex, but the basic principle is that the donee must only act in the interest of the donor. I mean, that's a general principle. And there's a whole list of what are the matters that he can or cannot act for. Interestingly, in relation to consent for medical procedures, this must be specifically conferred on him or her. You cannot act on behalf of a person who lacks mental capacity, even if an LPA, unless that has been specifically conferred on you to provide consent for medical procedures. And even that, you cannot take decisions like, for example, gender reassignment. That is prohibited, even if there's a power conferred to act for the donor in respect of medical matters. Now, formalities for the LPA, this is something very important. Unlike in Australia, all LPAs must be registered. If it's not registered, it is not valid. And like wills, the fact that there's a registration does not mean that it is valid. To be valid, an LPA must satisfy the requirements. But if it's not registered, then it's not valid. Similarly, the revocation of an LPA must also be registered with the Office of the public guardian, or the OPG. The donor must be at least 21 years old, and the making of the LPA must be witnessed and certified by a certified issuer. And there are persons who have been appointed and gazetted as certified issuers of LPAs. So you cannot just get a few friends together and type out your own LPA and submit it to the Office of the Public Guardian for registration. There are fees payable to the OPG, to the Office of Public Guardian, for the registration of an LPA. At present, it's $75. But in order to encourage people to make their LPAs, the government has waived this fee until March 2026. So if you're a Singaporean, please do your LPA as soon as possible. Otherwise, you have to pay $75 in order to register your LPA. Now, an interesting development was in 2001 when legislation was passed for LPAs to be filed electronically. And right now, the imperative is for LPAs to be filed electronically, even though the OPG has got a discretion to waive this requirement in specified circumstances. Now, to the topic we're talking about today, access to the LPA. The access to the LPA, in other words, who can see a person's LPA, is provided for by the 2010 Mental Capacity Regulations. Obviously, the donor and the donee can request for copies and or view the LPA anytime. The donee can also request for the LPA to be sent to another person, normally, for example, the doctor treating the donor. But for this, there must be a declaration that it has been medically determined that the donor is mentally incapable. A false declaration is a criminal offense. So there's a safeguard here. But there's also provision for any person, the word use any person, to apply for a copy of an LPA. However, there are strict controls here. There's a need for the person or the applicant to justify why he wants to see the LPA. And there are numerous considerations which are binding on the public guardian before providing a copy of the LPA to the applicant. But even without providing the person a copy of the LPA of a donor, the Office of Public Guardian is empowered to provide information of an LPA to a list of persons. Firstly, the next of kin of the donor. Secondly, a licensed healthcare provider. In other words, the healthcare provider must be a registered doctor, or the donor's embassy. This is in case of foreigners. Now, what does this all mean? All this means that the LPA, the registry of LPA, is not a public registry. It's not a public registry because the OPG has got fairly wide discretion as to who, actually the she, would allow to have access to the LPA. But there are sufficient provisions which are put in place to ensure that those who need to rely on the LPA can know that the donor or the person whom they're dealing with and whom they believe lack mental capacity has or has not made an LPA. With regard to the viewing of the LPA by another person, of course, reasons must be given, but it must also, as with everything else, be accompanied by a declaration that a person or the donor lacks the capacity to make decisions relating to either his personal welfare or his property. So finally, we shall come to Advanced Medical Directive. This is something that's been with us for some time. It was provided by the Advanced Medical Directive Act of 1996. As mentioned by Brian, another name for this would be the living will. And it's a written direction made in advance by a patient to an attending doctor, basically not to prolong his life using extraordinary means. As with all the other instruments, the maker must be above 21 years old and not mentally disordered. And like the LPA, it must be in a prescribed form. This form can be obtained from the website of the Ministry of Health Singapore. The LPA must be witnessed by 2 persons, and interestingly, one of whom must be a doctor. I tried to argue before the committee that was charged with looking into the enactment of this act that since the LPA is a legal document, the other witness should at least be a lawyer. Unfortunately, my views are not accepted. And the LPA must be registered with the Ministry of Health. It can be revoked anytime, but the revocation must also be registered with the Ministry of Health. Now, what's the difference between an LPA and an AMD, an Advanced Medical Directive? In the event of terminal illness, a medical practitioner can request that the registry of AMDs, which is held by the Ministry of Health, be searched to determine whether or not the terminally ill patient has met an AMD. And there's a process provided to determine whether or not a person is in a terminal stage of his life. A panel is established in order to determine this. But the Act makes it very clear that in all other circumstances, the AMD is confidential. Nobody can view that AMD or obtain information about it except for the doctors who are treating that patient at the terminal stage of his life. So that are my views regarding or the information that I have to share at this time regarding wills, LPAs, and AMDs. But I must say something about the general approach of the Singapore government to all these instruments of peace. A major non-legal instrument, of course, is the Advanced Care Plan. The Advanced Care Plan is not a legal instrument, but it's a written direction made to medical care providers as to how a person wish to be treated towards the later stages of his life. The policy of the Singapore government right now is to strongly urge all Singaporeans, particularly elderly Singaporeans, to drop all these instruments of peace, i.e. wills, LPAs, and AMDs, as well as ACPs, Advanced Care Plans. And considerable government resources have been devoted in order to reach out to Singaporeans, especially elderly Singaporeans, not only to inform them, but also to assist them in drawing up these instruments of peace. And hopefully this will progress in order to make life more certain and more comfortable for the elderly in Singapore. As you know, Singapore is a rapidly aging society. It's important that our aged persons, and I include myself in this, have our peace of mind as to what is to happen to us and our property as we proceed into our senior years. Thank you all very much. Now, in conclusion, I'd like to just mention something which I've been asked to mention, and that is whether or not there's any move in Singapore for a central repository for all these instruments. Right now, I believe, it's my view, that the view of the government and many people is that there are sufficient safeguards in Singapore to ensure that those who need to know about these instruments of peace in respect of any particular person can get to know them. So at least in the public space in Singapore, there is no pressure as such for a central depository for these instruments of peace. Thank you.
Well, thank you so much, Jeffrey, for your very detailed and informative presentation on the 3 instruments of peace. So now we learned that there is no one central registry in Singapore, but it has registries for lasting power of attorney and advanced medical directive. Well, it's not a public registry, we learned, because only accessible for specific persons, right? And I also appreciate that Singapore is very proactive in promoting and encouraging the seniors to sign up for the 3 instruments of peace, which is very important for all of us. So the last speaker, may I introduce Ms. Shelin G. Chen. Shelin is the founding chairperson of MIP Care Resources Connect, which is the first charity in Hong Kong that focuses on the needs of mentally incapacitated persons and their carers. She is also the head of family, mental capacity, and vulnerable client practice at Deacons. She is a leading lawyer in mental capacity law and a seasoned family and private wealth lawyer. Shelin is a fellow of the International Academy of Family Lawyers and chairperson of the Mental Health Law Committee of the Law Society of Hong Kong. She is also the co-chair of Society of Trust and Estate Practitioners, Hong Kong Branch Mental Health, Elder, and Capacity Law Subcommittee. Shelin is a frequent speaker on family and private wealth matters, both internationally and in Hong Kong. She is the author of a practical guide to mental health law in Hong Kong, published by the Hong Kong University Press. And congratulations, Shelin and her team just won the 15th Annual STEP Private Client Awards, Vulnerable Client Advisory Practice of the Year. Congratulations, Shelin. So, glad to have you. So please share your presentation. Thank you.
Thank you. You hear me? Yes.
Yes.
Thank you, Teresa. You're too kind. Just a correction. The 15th is it's not the 15th now. That was 3 years ago.
Oh, okay.
But yeah, we're still
congratulations.
yes, our team is still actively working on that. But I think I just want to start by thanking Active Aging Consortium Asia Pacific for giving me this opportunity to join the distinguished panels on a very important topic, I think, in our aging society. So as mentioned by Teresa, I'm a family lawyer. I'm based in Hong Kong for 30 years. And I would like to share a little bit about my experience on the increasingly important use of enduring powers of attorney, advanced medical directives, and wills in our aging community, and how these documents are dealt with in Hong Kong, and also share the results of a survey commissioned by MIP Care Resources Connect, which actually our moderator Teresa and I and 6 other amazing professional and caregivers have co-founded. Now, let me see if I can access and control the slides. Anne, would you give me access so that I can? I'm trying to go to the next slide. Well, you've heard from Brian and Jeffrey on how the 3 legal and medical instruments are treated in Australia and Singapore. And I will not delve into the details of these documents, except to mention that all 3 of these documents can only be prepared when a person has the requisite mental capacity. In other words, it would not be possible to prepare these documents if one does not have the necessary mental capacity, either due to sudden strokes, dementia, or other accidents causing brain damage and the loss of mental capacity. And that's why I think we say it's a peace of mind if a person is able to prepare all these documents before they enter that stage in life. So to set the scene, here are some government statistics on Hong Kong's aging population and dementia, which means that by 2036, 1 in 3 persons will be aged 65 or above. And the number of people over 60 with dementia will double from 103,000 to almost 303,000. So I think, oops, I'm trying, next slide, please. Yeah, thank you. Next slide. No, so, and during power of attorney, I think Jeffrey has already, given a very detailed and clear definition. So similarly, in Hong Kong, we have an enduring power of attorney, and it is governed by the ordinance, Enduring Power of Attorney's Ordinance. And it's different from an ordinary power of attorney because which becomes invalid if a person loses mental capacity. So the main difference, as we see, is that an EPA endures, the validity of the document endures even when the donor or the maker has lost mental capacity. Just to say, I'll highlight that an EPA or power of attorney deals with property and financial matters only. Now, the next two slides, which I will skip, talks about the 5 main elements of EPA and the formalities of EPA, which is very similar to what Jeffrey has just shared with us. Skip next slide, please. Yes. So I just want to highlight that in Hong Kong, there is a draft continuing power of attorney bill, which will cover directions in relation to a person's personal care as well as property and financial matters. Because as I understand it, in I think in UK and in Singapore, Australia, the power of attorney, the lasting power of attorney, will cover, can cover a person's, a donor's personal care as well as property and financial matters. There's a form that you can take. But in Hong Kong, the EPA only covers financial matters. But hopefully, the emerging continuing power of attorney will allow the option of choosing an attorney to help deal with personal care as well. Okay, so next slide. So I guess similar to an EPA, the CPA will also survive the mental capacity of the donor. And yeah, we look forward to the new ordinance. Now let's talk about the next slide, the advanced medical directives. So I think as the other speakers have mentioned, the advanced medical directives or living will is an expression of a patient's wish to refuse life-sustaining treatment under certain conditions. And in Hong Kong, it's very specific. It's when a person is terminally ill or in a persistent vegetative state or irreversible coma or other end-stage irreversible life-limiting condition. So this is different from the advanced care planning, which I think Jeffrey also mentioned, which is commonly used in hospital settings when a patient is able to discuss what type of treatments or care plans they wish to have at the later stage in their life. Whereas the advanced medical directive is restricted to refusal of life-sustaining treatments under the 3 conditions mentioned. So in recent years, a lot of my clients, when they come to my office and ask for, to do succession planning, they want to prepare a will or an enduring power of attorney, they are now asking if they can make a medical advanced directive in a non-clinical setting, because as they're preparing for these, they are thinking about end-of-life issues as well. So there's an increased number of non-clinical advanced medical directives that are being prepared. So the last document, which is next slide, the will. I think we are most familiar with this document, but now many clients, especially the elderly clients, are very concerned. After they've prepared everything, they ask me, oh, so where should I store them? So people sometimes store them at their own home or in the bank safe deposit boxes. But because of the limited number of boxes in the banks, a lot of people are unable to obtain a safe deposit box. And they're worried that if they put it in their home, people will not find it. And sometimes one of the things is that people, I think, especially even for myself, is that my memory is not as good as before, and people will forget whether or not they've actually made one or they've updated one. So I think a lot of law firms are now not storing the wills for their clients because of space issue or because of many other reasons. And so this has become an increasing concern for people who have made their wills. And so and another point I want to mention is that Hong Kong does not accept digital wills. And so if you cannot locate the original last will, the wishes of the testator may not be fulfilled, and it may sometimes cause a lot of complicated estate dispute between family members and beneficiaries. So similar to Singapore, I guess, Law Society of Hong Kong has a will search service. So but I recall a case where a family member actually made all the searches at the Hong Kong home and also did a will search at the Law Society and did not find any will. So they obtained probate based on intestacy and started to distribute part of the estate. But then midway, they found a will in one of the testator's other properties, probably a holiday home. And so sometimes these things happen. And with globalization, people becoming more international, having homes in different places, people are becoming mobile. The storage and location of wills and EPAs and directives is becoming more and more important and a hot topic. And I was very interested to hear from Brian about Australia's Lost Will Register, which is a very interesting development. And I think, yeah, we would like to hear more about that later. So the next part of my presentation is about a survey that we prepared. So the MIP Care Resources Connect, the charity that Teresa and I co-founded, we commissioned a survey in 2021 to find out how the people in Hong Kong store the 3 instruments of peace and to understand the need to establish a central depository to allow for safe storage, timely access and retrieval of the same to address these concerns. But I want to mention, maybe the name central depository is a little bit misleading. The idea of a proposed central depository is not so that it becomes public, because in fact, according to our survey results, safety, privacy, and regulatory oversight are all very important issues. You know, who will be able to access this? The concern that we want to address here is whether or not a person has made a will, and where is it stored, and hopefully, as we proceed to look into this matter deeply, whether or not electronic digital copies of these documents will be accepted in Hong Kong, and whether or not there will be a place for physical storage. But I think let me go through a little bit about the survey results, if Anne can help go through. In case I don't have time to go into detail, I want to just go through the executive summary first. Okay, so 85% of the respondents agreed that a central depository is necessary, and 83% indicated that they will likely use it if there is one. 67% believed that the service should be free. 77% agreed that doctors in government and private hospitals should be able to access, in particular, the Advanced Medical Directive. 81% believe that certified digital copy should be stored, and 67% want a place to store the original copy. So if you want to read the full survey, please go to our MIPCRC website and click onto the same. But here I'll give you a snippets of it. Can we click onto the next slide? Yes. So I think the profile is, we did it by gender, age, and the sample size was 1,014. And if we look at the, one of the questions that was asked is your planned location for retirement. So that's quite interesting. So most of the people will stay in Hong Kong, some in mainland, UK, Taiwan, Canada, Australia, Malaysia, Singapore, United States, New Zealand, and elsewhere. So you can see why this conference is very important. And we would really, in this global world, I think people have so many residences and they travel so much that sometimes they may forget where these documents are located. So in terms of overall, though, only less than 20% have actually prepared a will, according to respondents. And most of them who have a will indicated that they have placed them in a drawer at home. 20% in a lawyer's office, 40% in a safe, and 13% in a bank safe. So for those who did not prepare a will, also indicated that they wish to place their future wills in a lawyer's office. However, if we look at it, we asked the respondents whether or not the beneficiaries or the executor know of the existence and the location of the will. Those who have prepared wills said that only 67% of them know. So actually, there's still 33% of the people interviewed said that they have not told the executors that they have prepared a will. So I think this, the relevance of this is that if we prepare a document and the executor is not aware of it, and if you've forgotten about where you've placed and they are unable to locate it, then the wishes may not be able to be fulfilled. Now, in terms of those who have not made a will, those respondents, they indicated that they would probably like to say store it at the lawyer's office or at a bank. A lot of people were saying that this is it safe or is it not safe? Only 50% of the respondents say that it is safe to keep it at the law firm's office. 20, in fact, some people think that it's probably, in fact, the lawyers that we shared in meetings have indicated that they are not prepared to store it in their offices because of space, and also they are concerned that they might, move, or because a lot of our lawyers are becoming elderly ourselves, they don't want to be able to be able to keep the will for their clients. So that's the part about the wills. But regarding enduring power of attorneys, according to our survey, 93% of the respondents do not have an enduring power of attorney. So only 7%. But this number, even though it's percentage-wise, but the number of enduring power of attorneys prepared has increased drastically in the last few years. And when asked where do they place it? A lot of people place it, the enduring power of attorney, at home. Now, regarding registration, I just want to add a little bit about the enduring power of attorneys. Although we don't have a registry as such, all the documents, this enduring power of attorney will have to be registered in the High Court if the person is suspected to have lost their mental capacity. So it's a must. So in that sense, I know that some of the people who have prepared the enduring power of attorney, even though they are still mentally capable and competent now, they said that I don't mind, registering it first. So at least I know that it's safe because it's with the High Court registry. So I think this talking about where to, but there is a downside to it, because at the moment, if they register in the High Court, then it becomes a publicly searchable document, which I think there is some concern if the contents of the document can be searched by the public. So regarding family, whether the family knows about it or not, there's 79% or close to 80% say that they've told the family, but in fact, in our form, in the enduring power of attorney, the attorney has to sign. So at least the attorney would be aware that there is such a document. Okay, I'm checking the time. I still have some time. before we look at those that people who have not prepared the power of attorney, they think that 50% believe that the current storage at the law firm or at a bank, it's not that safe. And also they are concerned that it is not easily retrievable, because if it's when you want to use it and if it's in a safe, then you have to have access to the safe. And when the person has lost the mental capacity and they've kept it in a safe, then when they want to use it, it might take time to locate, and that is also a concern. So quickly through the advance directive, 95% of the people have not prepared an advance directive, and only 5% of the people said they have prepared it, and most of the people keep it at home. But as we all know that it is very difficult to predict when you will be needing this, especially for those who have prepared an advance directive in a non-clinical setting. So the hospitals and the doctors would not have access to it. Okay, so if we skip through, and I'm sorry, we're probably not synced in relation to this. Let's go to the next one. What do you think should be stored in this proposed central depository? So people, obviously, it's 90% of the wills, 92% EPAs, and 89% for the advanced medical directive. But here, as I mentioned, that there will be we think in Hong Kong, we eagerly anticipate that in Q2, in a later part of this year, that we will be able to have a new legislation, which is called the Advanced Decision on Life-Sustaining Treatment Bill. This is for the making of advanced medical directives and the operation of the DNA CPR to cover non-hospital settings as well. So the government has introduced this bill, and the second reading will be taking place. So I think shortly, very soon, we will be seeing this new bill in action. And with this, I think hopefully, I think there will be a very effective access and retrieval system for the advanced medical directions. So I'm sorry I've overrun, I think, but just to conclude, I think we hope that there will be a two-stage in Hong Kong development of a central registry. The first stage is just to indicate whether or not a person has made a document, and if so, where it is stored. And then second stage is that if we are able to have a digital or physical storage, and of course, all this will have to be, we have to address the concerns of safety, privacy, and not everyone will have access. Only the appropriate persons will have access to it. So I'll give the time back to Teresa. Thank you so much.
Well, thank you so much, Shailene, for your very interesting presentation, especially on the results of the surveys. So we have learned that, actually not many people have registered for the 3 instruments of peace. But fortunately, from the survey, we also learned that they are eager to have a central depository to keep all their legal documents. So finally, I think the conclusion is that Hong Kong has no centralized registry at this point. But hopefully, after the pass of the legislation at the Advanced Medical Directive in the second quarter, so, hopefully we have something new going on. So thank you so much for all the 3 speakers for your very fruitful and, very informative presentation. So I would like to open the floor now for question and answer. So if you have any questions or comments, please, just put it on the chat. and we'll be able to answer your questions. And please also put your name and country there so that we can address you properly.
I want to say something.
Okay. Okay.
Yeah, it's really very informative and interesting. Everyone is saying, and it's really very crucial aspect of the agings, actually for the older population. And India, you all give me a new perspective to look all these things in a new frame. And especially, I will do homework. And it's my request if in any way I can connect with all the speakers of today after a while, if there is any way, so it will be great for me. Thank you. And thank you for this session. It's really very interesting and informative.
Okay, thank you very much. Yes, the whole session is also being recorded. So, whoever missed the presentation today can always review the session today. And later on, I'll ask the permission of the three speakers. And then, if you would like to put down your email address on the chat, we'll get back to you. Thank you.
Teresa, there
So
appears to be a question that speaks to Australian law. I'm seeing in the
Yes.
chat, do you need two wills if you have properties in Hong Kong and Australia? And I think the short answer to that is depends. There are two issues attached to that. There's probably multiple issues. Certainly, once again, Australia is a federation, and so if in looking at formal validity, we similar to Hong Kong, we rely on the common law, which speaks to formal validity of a will would be for immovables, where the immovable is situate, and for movables, which is would be the domicile. So it's a domicile test. So the short answer is there's some tax issues there. And it's this big tension. Do you do two wills or you do one will? And for those of you that are specialists and really focus on this, may I encourage all my colleagues in preparing a dichotomy of what each will deals with, be explicit on the notion of property and whether it be movable or immovable, and where its situs is. And if that's how you differentiate, is my view, not so much this idea of I suppose tangible and intangible. That's not the dichotomy. It's the situs of immovables and movables. I collaborate with colleagues in different jurisdictions, whether it's one will or two wills. And I've got to share with you that we could spend a lot of time on this. There are a myriad of tax issues as to who you pick on to be your executor in administering an Australian estate. You can accidentally bring, say you're a foreign person and you've got some assets in Australia, by who you pick on to be your executor, you could bring in all the assets worldwide to be taxed under the Australian system. So it requires a lot of thought. I probably should be quiet for now because we were talking about registers today, but
Yes.
I saw that question.
Okay, thank you,
Can
Brian.
I give a view on that, Teresa?
Sure.
Can I provide
Yes,
a view
please.
on what Brian just said?
Yes.
I think it's very inadvisable for a person to make more than one will at the same time because of the principle that a later will revokes the earlier will. Now, I understand that there is a practice whereby people make different wills for properties in different jurisdictions, and this has been advised on. They are dangerous because if the will is being litigated in a particular jurisdiction, and through the recognition of court orders and judgments, provisions in their law, they recognize the other will in the other jurisdiction as valid. That means that the earlier will in the jurisdiction of that court would be invalid. And then, at least for the purposes of that court, if the other will does not provide for the property within the jurisdiction of that court, then the property will be deemed to be disposed on the basis of intestacy. So that is a danger there, and it has come about. It has come about. Although I'm aware that there are wills that are made that deals with property in different jurisdictions differently.
Teresa, thank you.
Thank you,
Can I
Jeffrey.
also add my
Yes.
2 cents worth?
Yes,
Because,
please,
yeah,
Charlene.
of course, we all know that we're not giving any legal advice here, even though we're all, wearing different hats. But I think just to echo, I think what Brian is saying, because it's talking about Hong Kong and Australia, we've done quite a lot of that. In a lot of times, it's a worldwide will, which is what Jeffrey was mentioning. You prepare one will, and it covers all property wheresoever, whatsoever situate. So that's what's possible. A lot of people have been doing. However, in recent years, I think because people have acquired property, landed property in particular, in different places, different parts of the world, and there is a tendency to have a separate wills for each country because of that law of less-situs, where the property resides for landed property. I think it's not a simple, answer to the question raised by one of the audience, but I think the important thing is because of all the implications of tax and various reasons, it's always good to collaborate. But just, from my experience is that, yes, normally you can do one will covering all assets, and that could be simpler. But I think with the complex, situation world we're in, that we are seeing a lot more separate wills for easy administration. And of course, Brian mentioned different aspects in different jurisdictions. So I think, yeah, I just wanted to share my experience as well. Thank you.
Okay. Welcome and thank you all the speakers. I have another question here for all the speakers. How is lacking capacity determined? By doctors, from a specific panel of doctors?
Hello. Hello.
Hello.
Hi.
I'm Bala speaking. Hello.
Oh, hello. Yes.
Hello, Bala. I'm Bala
Mara.
speaking. Dr.
Yes,
Bala.
Mara.
Yeah. See, in India, as such, all the papers are really very interesting and informative. Thank you. And to tell you about the Indian condition, in spite of the wills written by the elders, and in spite of the, government laws, we find that most of the elders or retailers, they are not very much taken care of. Now, that is the reason why so many old age homes have come into being there in India, we can say. So, how when it is misused or badly done by the others or the children, what are we to do? The elders.
Thank you. Yeah, thank you for your question. Any speakers would like to have a short reply?
If I could, Teresa, just prior to
Yes.
answering the verbal question, there is a question that came up prior to that, which was about how do you determine one's lack of capacity? How do clinicians do that? I think the short answer, there's 2 parts to that. And firstly, the common law position, which Australia has adopted, which is reflected in our legislation as well, is one is presumed to have capacity unless a court of competent jurisdiction finds that you lack capacity. And I think also attached to that, we have to remind ourselves that capacity is task specific and time specific. And so you may repose capacity to marry, but lack capacity to engage in a transaction. But I think it's how does the court of competent jurisdiction find one lacks capacity? Well, it's that symbiotic relationship between clinical evidence from a medical practitioner, but not just, oh, mate lacks capacity, to use the Australian vernacular, but such and such, the clinicians apply a legal framework of the various elements of capacity for the task at hand, and within that legal framework, apply their clinical mind based hopefully on testing and observation as to whether or not an adult lacks capacity. It's that professional evidence that a tribunal or a court of competent jurisdiction would make a finding. So that's the Australian answer.
Thank you.
Well, if I may add from the point of view of a litigator, whether or not person has the capacity to carry out a certain act, whether or not it is making a will or committing a criminal offense, is a question eventually for the court to determine when that issue needs to be determined in order to arrive at a legal outcome. Now, how does a court proceed to determine whether or not a person has mental capacity to make a will, to commit a criminal offense? That depends on the evidence. And Brian was absolutely right that as to how persons will bring evidence to the court as to whether or not a person has mental capacity. Now, very often there could be conflicting evidence from experts. One side, because of the nature of our adversarial system, the person alleging that the maker of that decision did not have mental capacity will have to bring evidence, medical evidence or psychiatric evidence to prove his assertion. And likewise, the adverse party, the other side, will bring in evidence to try to prove that the person actually lacked mental capacity. So the court will have to consider the evidence put for the court and arrive at a finding. So that is how mental capacity is determined. It's always, as Brian mentioned, fact specific to the situation where there's a need to determine medical capacity. And as I mentioned, it could be in relation to the making of a will, an AMD or an LPA, or it could be in relation to the commission of a criminal offense.
Thank you,
Yes.
Jeffrey.
Thank you. Perhaps I think Hong Kong is similar in the sense that we follow, well, mental capacity is common law, based on common law. It's time-specific, task-specific, and presumed. I think that's something we need to remember. But in fact, the question, I think, is how do you determine? So it's also, you know, in the evidence that's produced is medical or psychiatric. And in terms of when we have to prepare these documents, actually the requirement, the mental capacity requirement is slightly different in terms of the medical evidence as well. So it's for if you want to prepare a will, you know, the requisite mental capacity may be different from that of an EPA, or, you know, when we talk about Part 2 committee applications, that's another level. And then, of course, capacity to litigate, and they're all different. So I think that, you know, that is very similar to other jurisdictions.
Okay, thank you, Sherilyn. Any response to what the participant from India, Rama?
Yeah, I'd like to speak to that, Teresa. Yeah. My understanding of the question was if there is some bad behavior under the instrument, how do you overcome that? And I think there's, if I've misunderstood the question, please correct me. Look, I think I've got a couple of answers to that. One is principles of common law. It's often thought that when you're appointing trustees, it's better to appoint more than one because of the accountability between two. And I think if there are concerns of one attorney acting as a silo and being, you know, putting their hand in the cookie jar, so to speak, it would be perhaps to overcome that. Like if you, and those of you that have been exposed to studying auditing, or your auditors, it's good to have accountability to people. That's one practical way that there is transparency. I think that's my concern in Australia. It's a lack of oversight. We don't have the resources for the oversight, and whatever jurisdiction you're in, and you're agitating for the development of enduring instruments in an expansion in your jurisdiction. If I could just push the big idea that if whatever model you're working on, I would suggest there should be compulsory registration and oversight. If I could get that in this country, I'd be very happy, because I suspect the incidences of bad behavior would reduce.
Hmm.
In Singapore, in relation to the lasting power of attorney, there is, of course, provision, because it is a registered instrument and we have a public official that is responsible for the proper administration of that instrument. There's provision for the public guardian to step in if there is evidence of abuse. But I'd like to make a general point, which is every time we have all these situations where power is entrusted to another person, the basic regulatory framework to ensure compliance and probity actually is the criminal law. So that if there is a criminal offense which is committed on account of misuse of the powers conferred, very often that is a breach of the criminal law, and the consequences to the perpetrator of that offense can be very severe. So I like to underscore the importance of the criminal law in ensuring proper compliance with the duties which have been entrusted by one person to another.
Yes. So apart from
Thank
that,
you.
I just wanted to add that so in Hong Kong, for say the enduring power of attorney, the ordinance also provides for if there is suspected, we don't have an office of public guardian, but if there is a suspicion that the attorney is not managing the financial affairs properly, you could go to the High Court for an order to ask them to produce the accounts or to remove the attorney if it is necessary. So I'm sure, you know, in other jurisdictions there is similar provisions, but that is only if, you know, there is any suspicion or in relation to the attorney not acting in the best interest of the you know, the person. So I think there are some provisions that we can rely on to prevent that. But of course, I remember a case, actually a Singaporean case, that is it Yang, the saga Yang? I think the judge actually, there was an abuse of power of the attorney, and also elderly abuse, financial elderly abuse. And the perpetrator was, I think, sentenced to 9 years or 7 years imprisonment.
That's the criminal law.
That's the criminal law, yes.
Yeah. Well, thank you all. And I have a last request from Mara from India. So Mara, can you just please say your comment in 1 minute, because time is running out. Thank you so much.
Thank you, Teresa. Without saying, congratulations to all of you on a wonderful webinar. I think the concern in India and in few other countries, developing ones, where illiteracy among older persons is high and legal frameworks are little weak and bribery is quite in place, and the medical community is still not so much aware of the elder laws. And I mean, so we need to really generate a lot of awareness on elder laws in the community. And we need to really bring the people, the older people, the medical community and the legal community together and have some kind of more awareness programs where this information is shared. And it is being done. And I just want to share one case which was very successful, but after a long struggle, a lady, she was diagnosed with dementia, and the caretaker misused everything and took away the property and all. And the inheritors, the siblings had to really fight it out legally and medically to prove. So the ways there in India too, certain laws are there to protect the interest, but the thing is people are not using them. They're not aware how to go about it. And even registration of will and registration of assets and you know, property, all things is very weak. So there is a many chances of misuse, and elder abuse on this thing is really increasing. So we really need to work on these things in a very diligent and serious way. Thank you so much.
Thank you so much, Mara. Well, thank you all for your very interesting questions and comments. And I would really like to thank all our 3 distinguished speakers today for the very informative presentations on the definition, the process, the management and storage of the 3 instruments of peace on will, enduring or lasting power of attorney, and advanced medical directive in Australia, in Singapore, and Hong Kong. So, so we learned that preparing these 3 instruments of peace is very important to us because it really allows us to maintain control over our lives, ensures our assets and healthcare preferences are handled according to our personal values and choices. And it can also reduce stress and potential conflicts for our loved ones. So everybody has peace of mind. I'm sure you will agree with me that preparing these instruments of peace is a valuable investment. So now you have prepared your legal documents. What's next? How are you going to store and retrieve them from, you know, when you need it? So we learned from each jurisdiction that, you know, each jurisdiction has different central depository for each legal document. For example, in Australia, there is no national level central depository. Only Tasmania has one for power of attorney, while Singapore has registries for lasting power of attorney and advanced medical directive, which are only accessible by specific persons. So it is not a public registry. While in Hong Kong, we does not have any central registry, but we are hoping to see changes when our advanced medical directive is going to be legalized later. So overall, the centralized system for storing and managing the 3 instruments of peace can significantly improve the organization, the accessibility, and security of these critical legal documents. So ultimately, we're benefiting individuals, families, and the legal system as a whole. However, there also comes some common concerns, such as which organizations should take charge of the central depository, privacy and data security, accessibility, and user experience, transitional existing documents, etc. So today we have participants joining from 20 jurisdictions. So I'm sure that each jurisdiction has different system and management according to the culture, the values, the government system, resources. So maybe we can have another webinar next year to invite other jurisdictions to share and discuss. So finally, my key takeaway for you is we don't have a say to come into this world, but you definitely have a choice to take charge of how you want to exit in dignity and leave your legacy. So start planning for yours. Before I close, I wish to invite all of you to join our next webinar in August 24 next month, addressing aging issues in Southern Africa, and also the webinar on September 21st to discuss the depopulation of Japan. So please mark your calendar. Again, a big thank you to the 3 speakers and all of you who have joined us today. I understand that a lot of you have written on the chat that you would like to have the, you know, the recording for today's session, which I'm going to tell you that it will be on our website, the ACAP website. So I really sincerely hope that you will consider to join our ACAP family by just sending us your email address and become a member. And there are no membership dues, but you'll receive information about our monthly webinar, our quarterly bulletin, and also our annual ACAP conference. Next year will be in Fukuoka, Japan in March. So please send in to Catherine Bong, our president, the email, her email address, and then, you will be our member and you will see all our activities in the future. So we look forward to seeing you all again. Best wishes to you all and be well. Bye. Thank you and bye-bye.